This webinar was recorded on the 26th of August and is presented by the Centre for Law, Markets and Regulation at UNSW. Colleagues, Sophia, to turn the recording on, and that's happened now. So I'll hand over directly to Anton and ask him to present first. Thanks, Anton.
Thank you, Rob. Your soothing voice is a fantastic beginning of any presentation. And I'll try to share my slides. Hopefully they will work this time. And I will turn off my video. And before I start, I'll just say that I have never heard about a Copenhagen protocol to the Cape Town Convention. So this might be something for the future, maybe for a candidate for the 5th protocol, maybe on some new type of asset covered by the convention. So you might have given us a very good idea for the future. I think I'll pass this on to Unidroa. So hello everyone, and thank you so much for joining this session, whatever time of day it is in your location. I understand we have many international participants today, and I need to explain to our international attendees that the Cape Town Convention is a very hot topic now in Australia because there has been no precedent to date under this treaty, and so our courts are grappling with the convention in the ongoing proceedings involving Virgin Australia. So later on, David will discuss the aircraft protocol to the convention and its insolvency provisions, as well as the Virgin Australia case. It is a very important discussion. But having read the transcripts in Virgin Australia case, I can tell our courts are clearly struggling with the convention. It is essentially uncharted territory. And things that are obvious for those involved with the Cape Town Convention and its development are not at all clear for others. So, for example, the court was struggling with the concept of commercial reasonableness in the text of the convention. And for this reason, in my presentation, I will focus on the convention itself, and rather than the aircraft protocol specifically. I will focus on the philosophy of the convention in the broader commercial law context, and in particular on the underlying balance between the two opposing notions of commercial certainty on the one hand and state sensitivities on the other. Well, 30 minutes, well, I even have 25 minutes. That's not enough to cover any aspect of the convention in any meaningful detail, but let's see what we can do. My first point today is that in the context of legal harmonization, commercial lawyers are spoiled for choice. We have a broad arsenal of tools at our disposal: model laws, international customs, practices, international principles, and so on. As a result, we often settle for solutions that are not binding and have no more force than simple recommendations. This also means that there is less emphasis on unification via treaties. And sadly, we cannot boast about those fancy high ratification numbers of our conventions compared to some of the other areas of the law, such as environmental protection law or human rights law. Well, of course, things don't look too bad in case of procedural or conflict of laws conventions. And so here, the two arbitration treaties, the New York Convention and the Washington Convention, do stand out. Others, well, not so much. Things look much worse when we consider commercial law treaties aiming to harmonize substantive legal provisions. There is, of course, one leading treaty, the UN Convention on Contracts for the International Sale of Goods, with 93 states parties, and, well, frankly, just everybody else down there. So what about the Cape Town Convention? Today, the CTC is the second most ratified substantive commercial law treaty in the world. It has 81 states parties plus the European Union. It's getting somewhat close to the Sale of Goods Convention, although we should remember that the latter had 20 plus years head start. If you read the invitation for today's session, you may have noticed that today's event, the description for today's event said, in almost 80 countries, domestic laws on taking security over aircraft are superseded by an international treaty regime. And I've just said that there are 81 state parties to the convention. But don't worry, there is no mistake. The problem is that some states ratified the convention without ratifying any of the protocols, which of course makes no sense, since according to Article 49, the convention doesn't work at all without the protocol. So currently the convention has 81 state parties, but the protocol has only 78 state parties, counting both Qatar and Iceland. Both countries joined in 2020, although for Iceland, the treaty will only enter into force in October. So which three countries are missing from the protocol? So these are Seychelles, Syria, and Zimbabwe. Although, to be fair to Zimbabwe, the country never seemed to be very interested in the aircraft protocol. Instead, it signed but never ratified the space protocol, although I have to say I'm not very knowledgeable in the space asset finance market in that country. But anyway, I think it's fair to say that the convention has now reached such a number of states parties that the question for governments should be not why should you join the convention, but instead, why shouldn't you? Another big feature of the convention is not just ratification numbers, but its registration system. In January 2019, Aviareto, the Dublin-based operator of the International Registry of Aircraft Objects, under the convention, celebrated 1 million registrations. At a glance, just a few words about the convention itself, which will be helpful for David's presentation later, I suppose, as well. So initially, the development of the convention was driven by two problems. First, the lex situs conflict of laws rule was clearly inappropriate in the context of security interests over assets that frequently move between states. Lex situs means the law of the country in which the asset is located. And second, the regulation of security interests over movable property differed substantially across legal systems. So that was the starting point. But over time, the convention had grown considerably compared to its early designs. And by the way, the first draft, which made the chairman of the drafting group very proud, contained just 5 articles. Well, now it's not 5 articles, obviously, plus the protocols. But overall, the convention does 4 things. I'm overly simplifying things right now. So it provides for the creation of international interests in certain categories of high value and uniquely identifiable mobile equipment. It protects financiers via convention-specific default remedies. It sets out priority rules overriding domestic law, which is particularly relevant in the bankruptcy context. And it establishes an international registry for filing various interests against mobile equipment, not against the debtor. And on a personal note here, I just want to add that the convention was written by very creative people. If you look at Article 45 bis carefully, you will notice that the convention supersedes another treaty that did not even exist at the time of adoption of the Cape Town Convention. And if you open resolution number 1 of the 2001 Cape Town Diplomatic Conference, which adopted the treaty, you will see that the resolution, and I quote, takes note of the consolidated text of the convention and the aircraft protocol set out in the attachment. Well, the funny bit here is that at the time there was no attachment, it was not ready, so there was nothing to take note of, and still it's there. Anyway, the Cape Town Convention system currently includes 4 protocols supplementing the main convention, and they cover 4 types of high-value uniquely identifiable equipment: aircraft, railway rolling stock, space assets, and mining, agricultural, and construction, or simply MAC equipment. The newest protocol on MAC equipment was adopted in November 2019. I don't have the time to cover each of the asset types. I will just say that the classification is not always easy. For the purposes of the convention itself, aircraft engines are treated as separate aircraft objects, meaning there is no such thing as international interest in aircraft. There has to be a separate international interest against the airframe and a separate international interest against each engine. This is important in the Virgin Australia case because there are currently separate proceedings relating to engines. And identification of eligible assets under the convention was relatively simple for aircraft, as the market is more or less standardized and there aren't that many manufacturers out there. In contrast, it was a complete nightmare for the MAC protocol, mining, agricultural, and construction equipment, for which the newest 2019 protocol uses codes of the Harmonized Commodity Description and Coding System. That is not to say that the aircraft protocol has no issues of its own. Take, for example, the definition of helicopter engines and helicopters under the convention. The problem here is that the very straightforward duality of airframes and engines doesn't really work in the context of helicopters. Helicopters are treated both as a separate aircraft objects and as entire aircraft. And this leads to some odd mathematics, namely the combination of one helicopter frame, which is a separate aircraft object, and an aircraft engine, also an aircraft object, yields still one aircraft object, a complete helicopter. And this is clearly not the case for other types of aircraft. Well, the official commentary has developed workarounds. I know Soraya Good is very creative, and it's an amazing workaround, but still the odd classification was likely a result of drafting oversight at the time. Objectively speaking, ships could have easily satisfied the requirements of the Cape Town Convention. They're clearly the examples of high-value, mobile, uniquely identifiable equipment, and yet ships are not covered by the convention as a result of very unfortunate stance taken by the maritime sector, which is surprising, really, given the entirely different approach within the aviation sector. Arguments for the exclusion of ships were voiced by the shipping maritime organizations and were in truth self-serving. So those organizations argued that the convention might come in conflict with the other shipping conventions, and they also argued that maritime law, bless you, whoever that is, and also they argued that the maritime law should remain a distinctive international body of law and should be regulated by maritime international organizations. Boy, I'm so glad that the aviation industry did exactly the opposite. And speaking of industry, if we consider all the types of equipment covered by the convention, we will see that each industry was faced with unique challenges and each responded differently. Some treated the convention as an opportunity, others like an unwelcome disruption of sorts. So the aviation industry was in many ways the driving force behind the convention. And at least at one point, the convention could have easily become an aviation-only treaty. And going back to the early 1990s, among the respondents to an early questionnaire prepared by UNSW, the international organizations responsible for development of the treaty, there were both the aircraft manufacturers, and Airbus industry, and also aircraft operators, Air Portugal and Air New Zealand. The Boeing company joined the discussions later in 1994, and later Boeing and Airbus established an international industry group known as the Aviation Working Group, or AWG, which also included leasing companies and engine manufacturers, banks, and so on. And the AWG did a lot to promote the draft convention, sometimes too much. Several times they interacted with the governments without making it clear that they were not acting on behalf of UNSW, which created conflicts. And so it was later documented as unacceptable interferences with governments. As I mentioned, shipping industry didn't really provide a consolidated view, and the strong opposition from the international organizations resulted in the exclusion of ships from the scope of the convention. And finally, in the context of space assets, strong opposition from members of the satellite industry it didn't prevent the adoption of the space protocol, but that's not consolation really, because the space protocol has 0 ratifications to date. Well, there are many interesting stories to tell about the history of the convention, but we simply don't have the time. If you are interested, you may want to take a look at my upcoming book dedicated to the documentary history of the convention. It's based on the materials stored in the archive of UNSW that you can see in the picture. And I was greatly assisted by Soraya Good, the chairman of the drafting group, and many other people. So You might be familiar with Sorway's brilliant official commentaries if you're practicing in the area. The commentaries focus on the final text of the CTC. That's the point B in the lovely picture. My book explains how we got from point A to point B. That's covering anything from the original proposal by the Canadian government in 1988 all the way to through all the drafts and to the diplomatic conferences. Now, today, the Cape Town Convention really is an excellent litmus test of what is achievable in a modern commercial convention. It allows us to assess to what extent commercial factors prevail over the political concerns associated with state sovereignty. I think we should start with looking at the key commercial factor, the legal certainty and predictability. Now, this factor has been programmed right into the convention, namely its Article 5.1, which was clearly, as you can see, modeled on Article 7 of the United Nations Sale of Goods Convention with some adjustments. Now, previously I mentioned that one of the reasons behind the convention was the problem of using lex situs as a connecting factor for movable assets. Well, that might have been true for other industries, but not for aviation finance really, because here the lex situs problem had been largely immaterial at the time. After all, the 1948 Geneva Convention had already addressed the problem of recognition of rights in aircraft. Largely, I'm saying, but the aviation industry saw the Cape Town Convention as an opportunity to go beyond the Geneva Convention by increasing the legal certainty through adding an integrated and international system of remedies and priorities on top of that. And at the time, the AWG, the working group, was very pragmatic. It became clear at some point that full-scale harmonization of domestic laws was not realistic. So the industry sought instead to ensure unqualified recognition of the law chosen by the parties to financing transactions. And furthermore, commercial certainty argument was later used in economic benefit studies. For example, the 1998 INSEAD study was built on three principles, one of which was clear, transparent priority. And the principle of legal certainty was later used during the negotiations of the Cape Town Convention for so-called inter rorum effect. That is to justify the need for those provisions that the aviation industry really wanted. So they argued that without commercial certainty and the relevant provisions, the economic benefits of the treaty would not be achievable. So to facilitate commercial certainty, the convention even got rid of certain popular mechanics used in other commercial treaties. One such victim was the good faith principle. The convention is not concerned with the state of one's mind to ensure greater certainty of the priority system. Well, there is one exception, Article 27.7 of the Space Protocol, but that's immaterial. Another abandoned concept was the presumption that a commercial convention applies to matters involving an international element. And things were quite different during most of the development cycle, but the convention as we know it now equally applies to purely domestic transactions. These examples show just how much the convention has achieved in pursuit of legal certainty. But to think that this success was unqualified would be a mistake. A lot of forces were really pulling in different directions, and so concessions need to be made, and I'll just mention some of those limitations. So what were the limitations of commercial certainty? First is the problem of using uncertain terms. On the one hand, the convention got rid of some vague and potentially misleading concepts like good faith or public policy. And on the other hand, it kept others like reasonableness or materiality. So if you look at Article 8.3 of the convention, the remedies of the chargee must be exercised in a commercially reasonable manner. And there is a clarification which says that the exercise of remedies complies with the provision if it is in conformity with the relevant agreement of parties, except where such a provision is manifestly unreasonable. But this means that the provision is in many ways circular. Materiality can be found in Article 11 in the definition of default, where the default is defined as, I quote, default which substantially deprives the creditor of what it is entitled to expect under the agreement. Again, a circular definition using a materiality criterion. The commercial certainty narrative clearly lost a lot to the very strong sovereignty issues. In other words, fear that states will find certain provisions just simply too intrusive and refuse to ratify. And so there is no functional approach to security in the convention. The convention maintains the separation of security agreements, title reservation agreements, and leases. It was a rather early decision made in the early 1990s when the proposal to adopt the functional approach to security interests akin to Article 9 of the UCC was deemed clearly unrealistic. And there are some entrenched legal concepts that are another overriding concern. Interestingly, the convention almost managed to reverse the usual assignment mechanics. Well, I say almost because there was a last-minute change and it all went back to normal. So according to the first option, which was the prevailing approach until the year 2000, assignment of international interest carried the debt with it. But during the diplomatic conference, the approach was completely reversed, and under the approach we know now, assignment of a debt carries with it the transfer of the associated international interest. Now, bankruptcy rules have been historically a taboo area in harmonization of commercial law. And as a result, the convention favors minimal intervention to ensure that the survival of the international interest in bankruptcy is maintained and in order to ensure that priority position is safe in bankruptcy. And procedural rules are also typically a taboo area in commercial conventions. And so by default, the convention does not set time limits for national courts to issue a judgment for the creditor. But the history of the convention is quite interesting in this context because this was not really the case initially. In 1995, the AWG proposed strict timeframes for non-appealable final decisions made by courts. For example, 5 days for the grounding of aircraft, 30 days for sale or repossession of the aircraft. But despite a number of similar proposals by the aviation industry, the study group of UNSW moved in an opposite direction. They proposed instead a provision dedicated to so-called protective measures or advanced relief. Formally, it's called relief pending final determination in Article 13. So in other words, advanced relief provisions that we see today in the convention were the result of fear that states might not agree to strict timeframes written specifically in the convention. But importantly, of course, the more intrusive provisions are possible on the basis of a voluntary declaration made by states. And another aspect of sovereignty, just a few other aspects of sovereignty to remember. Well, there is the absence of supernal enforcement of state obligations under the convention. It's a textbook problem of international law that the convention did not dare resolve, even though there were several attempts in 1997, 1998 to provide for an international center for the settlement of disputes or boards of appeal to hear appeals brought against the registrar. And as we know, under the final text of the convention, appeals against the registrar for the aircraft need to be brought in Irish courts since the registrar is in Dublin. There is no mandatory recognition of orders, rulings, or judgments made under the convention, so the parties must rely on pre-existing international arrangements. And I already mentioned that the convention applies to domestic transactions by default, but technically the treaty makes it possible to exclude purely internal transactions. And finally, as improbable as it sounds, recently regulation of immovable property has also become a problem that the convention is grappling with. There are special provisions in the MAC protocol dealing with the legal status of mining, agricultural, and construction equipment associated with the land. Another issue to remember is the problem was the balancing of interests of different stakeholders. That is, interests of stakeholders other than the creditor. So first, there's the creditor's duty to exercise remedies in a commercially reasonable manner. It was discussed in the Virgin Australia case. And second, there's the chargee's duty to give reasonable prior notice to interested persons prior to enforcing the security via sale or granting lease over the charged property. And of course, courts play an important role in balancing the interests of the parties under the convention. So the court has a duty to compare the amount of secured obligation with the value of the relevant object prior to vesting of ownership in satisfaction under Article 9.3. And the court also has a right to impose terms protecting interested persons when issuing advance relief under Article 13. And the last aspect, the last sensitivity I wanted to mention is the problem of public interest, so-called public service exception. It's based on the idea that denial of public access to certain assets will create a disproportionate loss for the greater economy compared to the loss of the individual creditor. This issue is known to the aircraft protocol at all, so this protocol is as commercial as it gets. But other protocols, the rail protocol and the space protocol in particular, have addressed the matter differently. The rail protocol in Article 25 sets out a mechanism of compensation to the creditor in situations when the contracting state blocks repossession, use or control of collateral. And the space protocol in Article 27, instead of offering compensation, simply restricts the full exercise of remedies by the creditor during a certain period. And since I'm running out of time, I want to move to my final slide. Just some things to look out for, Cape Town Convention related. So in 2 weeks' time, there is a 9th annual Cape Town Convention Academic Project Conference taking place in Rome, physically and by Zoom. So that's a 2-day event, as always, and as far as I'm aware, it's going to be free this year because of the COVID, and there will be several insolvency-related panels. And so I have added a link to the UNIDROIT website, to the relevant project website, run by UNIDROIT this time. And also, we're expecting a call for papers for the 9th issue of the Cape Town Convention Journal, for which I'm the general editor, so it'll probably come at the end of the year. So look out for it. If you're interested in submitting papers to the journal, you're very much welcome. But please wait for the actual call for papers. Thank you very much. Rob, I'm going to stop sharing.
Okay, thank you very much indeed, Anton, and my humble apologies for getting everything wrong in the introduction. And just to remind people, if you'd like to ask questions of either Anton or David, if you could do that through the chat function, which you can get to by clicking the purple arrows on the bottom right-hand side of your screen and then go for the balloon. So I'll hand over now to David, who'll give an Australian perspective. Thanks, David.
Oh, hello, everyone. An Australian perspective from an Englishman who is a New Zealand citizen. Okay, well, I'm going to try to share my slides with you, so just bear with me. But having made that disclaimer about not being an Australian, I guess having listened to Anton's very international focus on the convention, the first disclaimer that I wanted to make was I'm not an international lawyer. The second one is I'm not an aviation lawyer. Third one is I'm not an Australian lawyer. So why am I here? Well, I do know something about the secured transactions and insolvency law. Okay, so let's see if this works with my slides. Okay, select a slide. Okay, can everybody see my slides? If nobody can see my slides, put...
we can see your slides, David.
Thank you, Rob. Okay, right. Well, what I'm going to focus on, I'm actually not sure what was in Anton's slides, which he skated over, but hopefully this will be a good segue. I'm going to focus more on, as Rob said, the Australian position, in particular, the interaction between the aircraft protocol and the PPSA, and secondly, its interaction with insolvency and also in the context of the Virgin case. Okay, so the first thing I want to talk about is the PPSA, because obviously, we have the PPSA, which came in effectively in 2012, and then the protocol came in Australia in 2015. And so how does the PBSA interact with the protocol? Well, the first thing to say is that in the case of any inconsistency, the aircraft protocol prevails, and that is actually specifically mentioned as a statute which overrides the PBSA. Okay. Secondly, Anton has talked about the rather peculiar definitions of aircraft and helicopters and engines, and these aircraft protocol definitions are picked up in the PBSA because at the time the PBSA was drafted, they were already thinking about, whether Australia should adopt the convention and protocol. So the PBSA definitions cover all types of aircraft, but the protocol only covers, let's say, larger aircraft. The protocol has some definitions which Anton didn't get to, which are depending on the number of passengers and the weight in kilograms of the cargo. Okay, so basically the PBSA covers all aircraft, but larger aircraft should also be registered under the register in Dublin. Okay, the second point to make is that the definitions in the aircraft protocol also cover accessories, parts, and all sorts of kind of paperwork and manuals and data and records which go with the aircraft or with the engines. And that has been relevant in the Virgin litigation. So I'll come to. Another point to make about the PBSA is obviously we know that the PBSA has a very wide definition of security interest. It's a very functional sort of economic definition of anything that's a security interest, whereas the protocol is more specific to three types, and that is leases, which is a very important aspect for the aircraft protocol, charges in the more traditional sense, sorry about the typo, and thirdly, conditional sales, or as we may call them, retention of title arrangements. So the aircraft protocol certainly covers most of the important things that we'll be concerned about, particularly aircraft leases. Then lastly on this slide, the PBSA does contain conflict of laws provisions. They're a bit rather kind of unnecessarily complicated the way they're drafted, but nevertheless it does have some. But Anton has mentioned the lex situs in his introduction, and the protocol does look more at whether the debtor is in a contracting state. Where is the debtor located? Where is it incorporated, etc., domicile. So it doesn't look at the lex situs, as Anton said. And of course that's important because aircraft are moving around the world, and the important point is that the protocol will apply even though the jurisdiction in which the plane happens to have landed is not a contracting state under the protocol. Sorry, I just had some problems with my slide. Okay, so just a few more points about the PBSA. So as Anton has explained, there's this international register in Dublin, and pretty much that applies to, international interest. So, charges, leases, conditional sales. There is a declaration, from Australia's point of view, that statutory liens are non-consensual liens for the purpose of the protocol. And what that means is that if you have a statutory lien, such as under the Air Services Act for navigation charges, that will not be governed by the priority regime under the protocol. And that really reflects the PBSA, because as you probably know, the PBSA excludes a lot of these statutory as well as liens which arise by operation of law. But in the case of the protocol, it's just limited to statutory liens. So that might be an important point, because you might remember that, I can't remember whether it was April or May, that Perth Airport, I think it was blocking one of the Virgin planes for a while. That was in the media. And I surmise that that's because they were trying to exercise some sort of, or assert that they had a possessory lien, because the airport, doesn't have a statutory lien like under the Commonwealth Air Services Act for navigation. Another very important point about the PPSA is that it has a wide definition of proceeds, whereas the convention is limited. The definition of proceeds for the convention purpose is just limited to kind of insurance compensation for loss. So that means it's really important for secure parties over aircraft to register under the PPSA as well, because they can get that wider definition, enabling them to trace into direct and indirect dealings with the original collateral. And lastly, accessions. Engines have already been mentioned by Anton, but also other types of items which are installed in planes or affixed to engines themselves, such as computers, audiovisual systems. These are basically carved out of the protocol, in the sense that domestic law applies if there's a domestic law which continues the rights in those items once they've been installed. So in Australia, in the PPSA, we do have provisions, as do most PPSAs or secure transactions systems based on Article 9, saying that, if you have rights in something, then once it's installed, your rights, the security interest continues into the installed item. You still have your security over the accession once it's been installed. And so those provisions in the PPSA still apply, okay, notwithstanding the protocol. And there's been a recent Canadian case that Justice Barbara Romain had to make a ruling on something called a powertrain on a helicopter, and she applied the equivalent accessions provisions of the Alberta PPSA. And incidentally, that case, the Third Eye case in Alberta, was the first Canadian case which had ruled on the protocol. So we can see soon that Virgin is the first Australian case. Okay, now I want to turn to remedies, and I'm getting away from the PPSA a little bit now. But just in summary on that point about the PPSA, I think the important point is that most people in the industry would think that you need to register under the PPSA as well as the international register for if it's large aircraft, because, as I've said, the definition of proceeds is wider. The accessions provisions in the PPSA apply. Okay. So the next thing I wanted to mention, I wasn't sure if Anton was going to cover this. I think we agreed I would mention it, was something called an IDERA. I'm not quite sure how you said acronym, but anyway, what it means is irrevocable deregistration and export request authorization. Now, this is basically an authorization, as its name suggests, whereby the plane can be deregistered from the registering authority, which in the case of Australia is CASA, Civil Aviation Safety Authority, I think CASA. And the idea of this is, I think it's a bit like, how in a security agreement, the debtor, the borrower, gives the bank or secure party the power to appoint a receiver on an event of default. So similarly, in this situation, the debtor is giving the secure party, such as a lessor of an aircraft, the power to deregister the aircraft and be able to export the aircraft. And this is really important because it prevents aircraft being taken away and flown to places which may not be contracting states under the CTC, and therefore frustrating the repossession and ultimately the rights of the secured creditor lessor. So Anthony Albanese was the minister at the time the enabling legislation in 2013 was passed, and he likened this IDERA to a prenup. So I'm making the analogy with the power to appoint a receiver which essentially is the power given by the debtor in the original security agreement. But a prenup if that works for you, okay? So this is a very important aspect of the aircraft protocol and the declaration which has been made to enable this remedy to take place in Australia. Okay, and so once this situation is triggered, then subject to the consent of any prior registered interest under the international register, then CASA has to, on receiving such a request, deregister the aircraft, enabling, as I say, it to be dealt with and flown somewhere else if that is what is required. Okay, now what I want to turn to lastly in terms of the general situation before looking at the Virgin case is the insolvency provisions of the protocol. Now, the insolvency provisions provide that there's two alternatives, A and B, okay? Now, I was always taught that you can only have two alternatives, and if you have more than two, it's a choice between three things or more. So, however, under the convention, there's no requirement for a contracting state to make a declaration that they're going to adopt alternative A or indeed alternative B. They can decide to make no declaration about it, and quite a few contracting states have made no declaration at all. And the important economic point about these declarations, some of these declarations which Australia has made under the protocol, is that by making these declarations, Australia has access to export credit discounts on the purchase of aircraft, and this was the main economic reason why Australia signed up to the protocol in the first place and made these declarations. Because if you don't make the declarations, or if you choose alternative B, which Mexico is the only country to have done, then you don't get access, as I understand it, to the very, very significant discounts. Okay, so Robert's telling me I've got 5 minutes left. So very important, alternative A, which applies in Australia, says that on an insolvency event occurring, the administrator shall give possession no later than the end of a period, which in this case of Australia has been declared as 60 days, later than the end of 60 days, and the date on which the creditor would otherwise be entitled to repossess. So in effect, what's happened is there's a maximum 60 days period after which the lessor or creditor is entitled to repossess the aircraft object. In the meantime, the administrator must preserve and maintain the object and its value. And the only exception is to giving back possession within this period is if the administrator cures all the defects and agrees to perform future obligations. And the courts and the administrator must cooperate and assist the creditor to achieve this. Okay, moving on. Looking at this in the context of Virgin, I suppose the first thing to say is that the situation has changed since we had ANSET, because we've got the PPSO, we've got the convention. I was going to talk a little bit about what's been happening in the UK, but I'll pass over that in view of the time. So under the Virgin administration, we know from the report which came out yesterday to creditors for the second meeting that's coming up in a week or so, that there's around 100 leased aircraft. Some are on finance leases, and then also, as Anton mentioned, there are leased engines separate from the aircraft. Now, Alternative A impacts and takes precedence over anything in Part 5.3a of the Corps Act, which restricts the lessor or the secured creditor's rights. So in the Intrepid Aviation case in ANSET, there was one of these situations where the lessor wanted to repossess the plane, The administrators wanted to keep it for certain purposes, and so applied to court under Section 441B in a way you can have leave to restrain the secured party from exercising their remedies. Now, with Alternative A, you've got that maximum 60 days, which overrides anything in the Corporations Act to the contrary. Now, in Virgin, number 3 Virgin decision, the issue there was the administrators applied for a further extension from them having personal liability under Section 443B of the Corps Act, which is the one which says that, if they continue to use any sort of property, they must pay rent or other costs, be responsible personally for other liabilities. Well, of course, we have Section 447A of the Corporations Act, which enables the court to amend any provision of the Part 5.3A in relation to the particular company. So the administrators were successful in getting a further extension, but the further extension they were seeking was still within the 60-day Alternative A period. So Middleton was quite comfortable in making that further extension, which negates the administrator's personal liability within that period. The context of that was that the administrators, rather confusingly, were negotiating protocols, which they confusingly called aircraft protocols, with the lessors in relation to obviously wanting to continue continue the contracts in relation to certain planes whilst they were negotiating to sell the Virgin business ultimately to Bain, as we know now. And they hadn't quite finalised these protocols at the time they applied to court in Virgin number 3. Okay, so the COVID context, which I just wanted to mention there, was that the judge noted the commercial reality here was that the lessors were unlikely to get any other short-term benefit from, an earlier surrender of the planes by the administrators. So it was quite comfortable to extend the personal liability until the 16th of June, which was a few days before the 60-day waiting period expired. Okay, now, just very quickly, and hope, Rob, that you'll give me a few more minutes because I think I'd started a bit late. Okay, talking about time frames as we were. So I just wanted to quickly mention the other piece of litigation in Virgin, which is underway, and we don't yet have a judgment on that, but it was mentioned in the administrator's report to creditors yesterday that they're pretty sure from looking at the way the hearing went that the court is going to find against them and in favour of certain engine lessors that Anton mentioned were involved in this litigation. And so you've got Wells Fargo and Willis and one other lessors of certain engines who did not agree a protocol like many of the other lessors with the administrators and wanted their engines back. And these engines were due to be repatriated to Florida, I think it was. So there is a dispute underway, and the administrators have indicated they're probably going to lose that case, but they've also indicated they're going to have an expedited appeal, apparently before they've even read the Middleton's judgments. So they're going to appeal anyway, according to the creditors' report. So the possible issues when looking at the transcript, Anton's commercial reasonableness as one that he picked up. Also, the notice which the administrators have to give under Section 443B, sometimes called a non-use notice, that was given in this case in relation to these engines on the 16th of June. And the argument in the litigation was whether that notice was sufficient to comply with the notice required under the Cape Town Aircraft Protocol for Alternative A purposes. So that's one issue. A perhaps slightly broader issue is whether Alternative A and the remedies in the protocol are supposed to be self-help remedies. And Australia, it's worth noting here, has chosen a declaration that all remedies could be exercised without a court order. So how far must the administrators go to assist the lessor in repossessing the aircraft? And in particular, in this particular piece of litigation, the issue was around certification. There's quite a lot of certification and documentation required and testing of the aircraft, or the engines in this case, before they're, certified to be, in this case, they were to be ferried from Adelaide to Florida attached to some planes, and then these planes were going to come back to pick up the other two engines, I believe. So there is dispute about how far the administrators should go under the protocol to assist. Lastly, there's an issue about the, whether the court under 443 can excuse personal liability in respect of other amounts apart from rent. Well, whether or not the case is appealed by the administrators, it will be the first decision that we have in Australia on the protocol. Just want to finish off by saying, look, I think that COVID may have diluted the commercial impact of the protocol, because obviously, when the protocol, global pandemic was not predicted. And, as I said, since ANZAC, we've got the PPSA and the protocol, which is great. But, I think the reality is, obviously, if you're a lessor right now, probably your options are limited in terms of what else you can do with your planes. They're all lying in the desert or wherever. And obviously, there are planes still operating, and Virgin has been operating some of the planes throughout this process of the VA. But I think that if we didn't have COVID, things would be obviously rather different. But nevertheless, I say that the COVID may have diluted the impact of the protocol, but still we can see in the Virgin case that the protocol, particularly Alternative A, with its 60-day maximum time limit, is having an important impact. Okay, so I think I'll stop there because I have run over time. Back to Rob.
Thanks very much indeed, David. That's great.